The Texas House Bill 1181 has the goal to limit minors' access to sexual materials online by enforcing age verification requirements. However, it raises concerns on whether it adequately protects free speech and whether it can effectively fulfill its intended purpose. This law requires websites with more than 1/3 of content that is considered to be inappropriate for minors to verify the ages of those who choose to access these websites.
The government has the authority to restrict speech that isn't protected by the First Amendment or deemed as obscene content when going through the Miller test. It doesn't mean the government should place these restrictions regardless of the content if obscene, inappropriate, or any type of other speech. This is why the House Bill 1181 is doing. Therefore, it should be examined using strict scrutiny. This is a high standard that the law must meet to consider the constitutional, especially when it comes to protecting free speech. Historically, Supreme Court cases suggest that strict scrutiny and consideration of existing artistic value in adult content should be taken into account. Some people argue that pornographic material and nudity have absolutely no artistic value for minors. They still hold significance for adults. Content that might be inappropriate for younger audiences can still be considered valuable in art and literature. This is comparable to getting your tongue ripped out of your mouth, unable to freely express your creativity. This idea was supported in the Supreme Court case, Ashcroft v. Free Speech Coalition, which stated that there is no artistic value in some of these materials, even if they may not be suitable for all ages. The discussion gets more complicated when considering previous Supreme Court cases related to obscenity. Significant cases like Miller, Ashcroft, and Ferber all provide insight into how courts have treated laws that have governed obscenity and free speech. These cases strongly suggest that the strict scrutiny should be the method used to review House Bill 1181 instead of the rational basis review that was applied by the lower court's decision.
House Bill 1181 would not pass under strict scrutiny. In the previously mentioned cases, the government was not able to show that the restrictions would effectively prevent minors from accessing harmful material. Similarly, House Bill 1181 faces the same skepticism. Can it stop minors from seeing inappropriate content online? The Texas law shares many similarities with the Child Protective Act, which was struck down because it failed to provide adequate protection for free speech and did not prove it could fully shield minors from harmful material. The lower court mentioned a case called Ginsburg v. New York to justify using the rational basis review for House Bill 1181, but this reasoning has been questioned. Ginsburg involved physical locations and only applied to brick-and-mortar stores, whereas House Bill 1181 specifically targets internet websites, making them fundamentally different in many ways. Digital age verification, for example, can pose unique risks, as submitting identification online can lead to issues like information retention by companies. The situation is very different from simply showing an ID in person, which carries absolutely no risk. The responsibility for monitoring content should lie with the parents, as various parental control options are available through devices and third-party applications. The bill defines minor as somebody under the age of 18, creating a broad category that doesn't account for varying maturity levels. What is appropriate for a 6-year-old is often different than what is suitable for a 17-year-old. The law's broad reach also raises concerns about its implementation, as it targets websites where more than a third of the material is considered harmful for minors, making it challenging for these platforms to measure compliance. The potential penalties, including fines for unintentional minor access, may lead websites to excessively censor their content, suppressing material of literary, artistic, political, or scientific value that is protected under the First Amendment. Overall, the bill's overreach risks Overall, the bill's overreach risks impeding free expression and places undue restrictions on both businesses and adults.
The overall debate around this law is complex and reflects the ongoing struggle between protecting children and ensuring the rights of free speech are not infringed upon.
What, if any, is the value of low-level speech such as pornography?
Low-level speech, such as pornography, may be obscene to minors, but that does not make it obscene for adults. It is valuable for adults to be able to access all kinds of speech because some content that is inappropriate for minors may have literary, artistic, political, or scientific value for adults. Adults having access to all kinds of speech reflects the values of freedom that the citizens of the United States deserve and are promised by the
First Amendment created to protect this kind of speech does not matter here.
The First Amendment was created to protect all types of speech, including low-level speech. The lead author of the First Amendment, James Madison, had the intention to protect all types of speech, regardless of its obscenity, when writing the First Amendment. Despite this historical factor, low-level speech, such as pornography, is considered obscene and is not constitutionally protected under the First Amendment.
Whose First Amendment rights are impacted by the Texas law? Is it minors, adults, or the platforms themselves?
Both adults and the platforms themselves are impacted by the Texas law. The content it is limiting is obscene to minors alone. It is limiting adults' access to free speech and expression, as well as creating a chilling effect that is deterring adults from accessing content that they have the right to view. The platforms are owned by private companies, which have the right to free speech.
Why can or can't the government simply ban access to pornography online?
The government cannot simply ban access to pornography online easily, as it partially still goes against the First Amendment. The First Amendment protects private entities such as companies, individuals, and groups from restrictions that are imposed by the government. Private companies, including privately owned websites, are protected from the First Amendment. Restricting pornography as a whole violates the First Amendment and would have an economic effect on the U.S., as the estimated revenue for the pornographic industry is approximately $15 billion a year.
In what ways is the Texas law a content-based imposition on speech? In what ways is it not?
The Texas law restricts adults from freely accessing this type of content. This creates a chilling effect. Adults are being discouraged from wanting to visit and access the websites freely. Anyone would be hesitant when having to present government identification online, especially when it will be linked to viewing adult material. House Bill 1181 is deterring adults from accessing content that they have the right to freely view.
Is including social media and search engines under the age verification requirement the reason to find this law unconstitutional?
As mentioned in the previous answer, a chilling effect is created by including social media and search engines under the age verification requirement. Therefore, it is a reason to find this law unconstitutional, as it restricts people's freedom of speech through social media and search engines, causing them to be more hesitant to freely search or post something. It would also likely cause the social media and search engines to be even more restricted, as well as creating huge privacy concerns with the age verification requirement.
The law requires age verification when more than a third of the website's content is inappropriate for children. Would the law be more or less burdensome if the threshold was increased?
The law would be less burdensome if the threshold was increased. The reasoning for this is that there would be fewer websites that would require age verification, taking the burden off of some adults and commercial entities.
Ashcroft v. ACLU applied strict scrutiny to the law that burdened adults' access to online speech, not the rational basis test. Why should the court not apply the same standard here?
There are no reasons for the court to not apply the same standards here. The age verification requirement in House Bill 1181 infringes on adults' rights and places a burden in those adults similarly to those in Ashcroft. Despite the speech being restricted, is referred to as obscene to minors in House Bill 1181. The content being restricted content is not obscene to adults. The court should apply the same standard here as it is considered speech, whether or not it is obscene.
Ashcroft v. ACLU identified that content moderation through filtering settings was a less restrictive means of protecting minors online. Has that proven true in the time since Ashcroft?
It has proven true in time since Ashcroft v. ACLU that using content moderation through a filtering setting is a better option, being less restrictive. Instead of putting the burden onto the private companies to have a required age verification system, it puts the burden on the parents. Parents should handle the burden of adding parental controls to their children's devices. The Texas law requires all websites that are obscene to minors to have a restriction in the form of age verification.
If the court were to find that the Texas law burdens the First Amendment rights of adults, does that mean petitioners win?
If the court were to find that the Texas law burdens the First Amendment rights of adults, it means the petitioners have succeeded. When House Bill 1181 falls under strict scrutiny, the court will be subjected to see it fail. There are many reasons why it would fail to fall under the review of strict scrutiny, as a law would need to be absolutely perfect and not infringe on anyone else's rights, which the Texas law will undeniably fail to do so.
Adults concerned for their privacy may not access websites requiring age verification. Is that a sufficient reason for striking this law down?
Yes, it is a sufficient enough reason to strike this law down. The government should be concerned with protecting the privacy of its citizens. The worry and concern for adults having their privacy invaded by age verification required by the law creates a chilling effect, deterring them from accessing free speech. Even if there is a punishment and fine for retainment of information from the age verification, it is a valid concern for adults to have. Adults are discouraged from visiting websites that have more than 1/3 of obscene content. If the government's true interest is to protect the welfare of children, there are plenty of less restrictive and less invasive means of how to do so.
If the court finds that the law requires examination under strict scrutiny, does that mean that the petitioners win?
If the court finds that the law requires to be examined under strict scrutiny, it does mean the petitioners win. Strict scrutiny evaluates the laws rigorously to face their final decision, and the law being presented must not infringe on any constitutional rights. It requires a nearly or even impeccable law. It is a rightful high bar to achieve. With this in mind, the Texas law cannot and will not pass when examined under strict scrutiny.
Are the privacy concerns presented by online age verification similar to the privacy concerns required to access age-restricted purchases in a traditional brick-and-mortar store?
No, the privacy concerns presented by online age verification are much higher than the privacy concerns presented by purchasing age-restricted products in a traditional brick-and-mortar store. In-person transactions only require you to briefly show your identification, while online age verification requires you to upload your government ID. Adults are going to be hesitant when having to present identification online, especially when it's going to be tied to viewing pornography.
In the years since Ginsburg v. New York, have increased technology capacities increased or decreased the privacy concerns associated with age verification processes?
People have had higher concerns regarding their privacy when going online due to the tremendous technological advancements that have been made in the 21st century. Ever since the case of Ginsburg v. New York, a case in 1968 is undoubtedly going to have a major difference beside a case that is being presented in the 21st century. The accumulation of technological improvements over the year has made access to private information easier for information brokers and makes identity theft easier. So it is hard to ensure a person is fully safe from the retainment of information.
Online access to harmful materials presents unique obstacles to parents trying to protect their kids. If this law is found to be unconstitutional, what else can Texas do to protect minors accessing online materials?
The state of Texas can encourage parents to use parental controls on their children's devices. Parental controls are provided by many major tech companies and major internet service providers, as well as third-party applications that can be used.